Hi, welcome to Family Law with Justine Clark. Today I'm going to talk to you about superannuation and superannuation splitting.
In my divorce, how is my superannuation going to be treated?
That depends on the length of your relationship. There are generally two ways in which the court can treat superannuation, subject to whatever agreement you and your spouse reach together. The first is in longer marriages, the court tends to equalise superannuation. What that means is the court will split the entitlement of one party that holds more superannuation than the other to the spouse with the lesser superannuation entitlements so that both parties then have the same amount of super going forward. That's called an equalisation of super or a superannuation split. That usually occurs when both parties have accumulation funds. In some circumstances where parties have a different type of superannuation entitlement, such as a defined benefit entitlement, that can complicate superannuation splits. Defined benefit entitlements have a greater value than accumulation entitlements and are calculated differently under the relevant family law superannuation regulations. What that means is often that entitlement, if you have a defined benefit entitlement and people working in the armed forces, in education, in fire and other responding services, will often have defined benefit entitlements. There are a few of them left. Some are, for example, ESS super. There are some in uni super and some in defence super. Those need to be calculated and valued separately. And then there needs to be a consideration dependent on the relevant superannuation deed as to whether or not those entitlements can be split, as well as a consideration of the taxation consequences arising from any split, assuming that that is possible. The second way in which superannuation can be split is in shorter relationships. And often the court can take an approach pursuant to a decision called Western Green, whereby the superannuation is effectively equalised over the duration of the relationship and marriage. So if one party or the other had significant superannuation at the commencement of the relationship or has accumulated significant superannuation after separation, then you can have an argument about whether or not that the superannuation split should be contained to the relationship. The court has the discretion to, of course, equalise entitlements, but it is often worthwhile having a debate about it, particularly if the other party is otherwise getting a windfall that they wouldn't otherwise have received.
I spent a lot of time out of the workforce looking after our children. What impact does that have on our superannuation split?
Generally, in circumstances where in a marriage or relationship, one party has been out of the workforce more than the other due to care of children or similar issues, there will be an equalisation of super in the context of that relationship or marriage. That is because the superannuation split is intended to compensate the spouse who has been at home caring for children and been out of the workforce, not earning any money and not earning any superannuation, to be compensated for that non-financial contribution during the relationship and marriage. That's because the other spouse has had the benefit of the other party caring for their children. And the court likes to ensure that women are not generally, because it is generally women, but it can be men, are not generally disadvantaged by their time out of the workforce in terms of the superannuation split that's affected in those sorts of relationships and marriages.